We're in. Let me get one folder open and then we'll get started. There we go. All right, good morning, everyone. This is the matter of Ronald Grayson versus Derek Grayson. It's 2019 CV321339. I'm Judge McBurney. We are live on Zoom. This is being shared via YouTube so that if either of your clients wants to be involved, he can hear and see everything that we're doing through a YouTube link that is found on the Fulton Superior Court's website. I'm going to take attendance here. I see that we've got counsel for Ronald Grayson, our plaintiff. That's Mr. Clark. Good morning, Mr. Clark.
Good morning, Judge, and I apologize I'm not wearing a collared shirt, but I am on vacation this week and realized I did not bring one with me.
That's all right. You're here. That's the most important part. So at least you're wearing a shirt. So whatever the vacation is, you got a top on for now. I hope you're somewhere fun. Derek Grayson is the defendant. Mr. Bastian is on the phone. Good to see you, sir.
Good to see you, Judge.
Ms. Niles is on. That's my staff attorney. And then there's someone I don't know or recognize. Who would El Kaba be?
My client listening? I'm not sure.
I think it's my client. I think it's Ronald Keith Grayson.
Okay. He's welcome to listen. I've muted him. As long as he's listening passively, that's great. And unless you were going to have him testify in some way, otherwise we'll have him use the YouTube channel if it doesn't work out having him listen in, but he's more than welcome to listen in. So let me tell you where I think we are, and then we'll dive into this. First, there's no takedown occurring. I assume both of you agreed we don't need a court reporter because it was on you all to have the court reporter dial in and join us. Is that correct, Mr. Clark?
That's correct. We don't need it taken down. Okay.
So I'm going to give you my thumbnail, and then I'll give both sides a chance to say, Judge, you actually got the wrong case. And then we'll get the right case. The Graysons are brothers. They have a sister. They had a mother. She passed away, and she left behind a piece of real estate at 135 Fairburn Road, where Mr. Bastian's client lives right now. So Derek Grayson occupies the house. Ronald Grayson is seeking a partition because he believes he has an ownership stake in it. The size of that stake, TBD. We'll talk about that. But he doesn't get to live there. And Derek's not paying him. I'm going to use first names, not because I'm being informal or disrespectful, but everyone has the last name, same last name. So that's why I'm saying Derek and Ronald. But apologies in advance, Ronald Grayson and Derek Grayson, if you're listening in. Derek's not paying rent to Ronald. Ronald doesn't get to live there. So what's he getting for his share of that real estate? That's sort of the plaintiff's position. Defense's position way back when, but it has a little more teeth right now, is this is a probate matter. We'll talk about is it or isn't it, because there was this surprise probate filing just as the COVID crisis hit. Two wills. The first will left, when I say the property, I mean 135 Fairburn Road, to all three siblings, sister and two brothers. Everyone got a third. And then there's supposedly a more recent will, the thing that's being maybe probated now. That's the October 2008 will, which revoked the 2007 will. And for whatever reason, I guess Ronald hadn't been nice to his mom, or mom got mad at Ronald. The property goes only to Derek and the sister. Kimberly is her first name. She's got a Whitlock, Ms. Whitlock. It goes to Derek and Ms. Whitlock. And then I don't have the will in front of me, but somehow the language of the will limits Ronald Grayson to only a 1/3 future interest if the property is sold. And it's my understanding that it's that will, the 2008 will, that is maybe now in a pro se probate proceeding. Ronald wants his share, he files a petition, and then another petition, and then a third petition. So I don't know what kept changing in Mr. Clark's mind, but we're going forward on the third petition. As I understand it, there's no quiet title claim anymore. And it's seeking a partition, but through a slightly different means than the earlier petitions did. It's partition as what they call heirs property. And I'll tell both you gentlemen, I know very, very little about how partition works and what happens in probate court. So I look forward to being educated by you all. Also, declaratory judgment claim to establish once and for all what is Ronald Grayson's stake in the property, and then an accounting and rent. Assuming Ronald has some stake in the property, he ought to be accruing some benefit from that. Oh, and one other important fact. At some point, irrespective of what the wills say, Kimberly Whitlock said, I'm out. Brothers, you each get half of my stake. So either the two brothers each have a half share because everyone had a third, and then each brother picked up a sixth each from sister, so they're 50-50, or Ronald Grayson has 1/4 because he got half of the half that Ms. Whitlock had, and Derek Grayson has 3/4. But it sure doesn't sound like under any set of facts does Ronald Grayson have no stake in the property, which means he's got a basis to say, I ought to get something out of this situation. We've got cross motions for summary judgment. They talk past each other a little bit, and they also predate the most recent petition. So we'll need to work through what arguments really still apply. But what I want to start with are two things. And we're going to start with Mr. Clark, and then we'll get to Mr. Bastian. I want to start with number one, what did I miss, so that I'm on the right page with you all? And then number two, what is the effect of the apparent probate action that is proceeding? And I say apparent because Mr. Bastian forwarded the petition, whatever it's called, to get into probate. And it looks legit to me, except it's not notarized. I don't know if it has to be notarized. There is a witness who signed it, but she didn't notarize anything. And so I don't know if that's going to mean it's not even a valid probate petition, and maybe we're heading in that direction. But let's start with those two things. Am I talking about the right case, and am I sort of in the right place? And then two, what is the impact, if any, of the fact that there is now apparently a probate action? Because I want to make sure we don't do what you must not do on the bankruptcy side, which is step on the toes of another jurisdiction. And if I ought to stay out of this while it's in probate, and that's where Mr. Clark ought to be going to bat for Ronald Grayson, then super, and we can stay this until the probate action is resolved. You're up, Mr. Clark. Live from where? Where are you?
Lake Lanier.
Boy, you don't go very far for your vacations. All right, you may see my son. His baseball team's going to be on a pontoon boat tomorrow. So don't drive your speedboat into a pontoon boat full of little kids, or I'm coming after you.
I will steer clear.
All right.
Yeah, that's a great summary. Probably better than I was prepared to do. I think you got it all correct. I'll briefly talk about why I amended the petition. It sort of struck me that once we got into it, it wasn't really a quiet title action because there wasn't really like an instrument that was a cloud on the title.
Mm-hmm.
It's more of a declaratory judgment as to what exactly do we own in this property, and then where do we go from there. So that's why we amended it and took out the quiet title. You know, I think that there's three different kinds of partition actions in Georgia. One's an equitable, which is basically where you, judge, just figure out the best way to deal with the property, have it sold, and split the money. It's very informal, no rules, requirements, etc. The statutory partition, a little bit more complicated. You appoint 3 appraisers essentially, and they come up with a value. And there's a series of steps that you go through before it's sold. And then finally, there's the heirs partition, which I've only bumped into once or twice. And that, I think, is what applies here. It's either this one or the equitable one. And it also has a series of steps that you take before you get to selling it on the courthouse steps. The idea is that if the property is owned by a certain percentage of relatives, then it is deemed heirs property, and it's sold under this statutory scheme. The idea was it protected heirs from being paid pennies on the dollar from some greedy investor, and they lose out on a valuable piece of real estate simply because it's fractional. The interests are fractional. I think we probably qualify under the heirs partition here. I'd be happy to go under the equitable. I think we can agree. I think we would be able to agree on how it is done should we get to the partition sale. So that's kind of how we amended the petition. What is the effect of the probate? I don't think any, and here's why. I think you hit it on the head of if we were under the 2007 will, where everyone gets a third, based on Kimberly Whitlock's deed, it's 50-50. If there was no will, it would be exactly the same outcome, 50-50, based on Ms. Whitlock's division of her fractional interest to her brothers. And I also believe we're in exactly the same case under the 2008 will. Although the petitioner, Ronald, would have been cut out of the ownership interest under the will, his sister gave her interest, to her brothers. So now we do have an ownership interest, no matter which way you slice it. That gives us, and the probate doesn't change anything. It doesn't divest anybody of anything. It just directs how the property is going to be conveyed. In other words, there will be a deed an administrator's deed that would vest title under the will. It would have gone to Kimberly, but now because of her actions, I think it'd read differently, probably 25% to us and 75 to Derek. That gives us the ownership interest in the dirt, giving us standing for a partition. Now, if we're under the 2008 will, once it's sold, my client, Ronald, gets his 1/3 of the sales proceeds, and he's acquired half of his sister's. So you add that together, we get 50% of the sales proceeds. So no matter which will we're under or no will at all, it all shakes out 50-50 at the end of the day. And that's where we are. So I don't think the probate, there's no prohibition. There's no, like, bankruptcy is a automatic stay if something's in bankruptcy. There's no such automatic stay in probate court. You can see under the Heirs Partition Act that the legislature has contemplated the Superior Court determining how this property gets sold. And it doesn't matter that it filters through a probate proceeding. The property is going to end up being owned by brothers, and therefore we have the statutory authority to partition it. So that's it. I don't think it changes.
Okay. So we'll dive deeper into some of those arguments, but I want to hear from Mr. Bastian first. You agree that we're sort of now operating from the same set of facts, or is there something you want to add or subtract?
So mostly, Your Honor did a good job.
Well, Ms. Niles did the good job. I just read what she wrote. So she dove deep into the file, but thank you.
Yeah, but a couple of things change. And, unfortunately, with the practicing law, as we're getting ready for this, things are surfacing. So about it, yesterday, I say, okay, the thing is tomorrow. What happened as far as, and I'm ready to tell my client about the fact that he never filed a probate action and the ramifications of it. And of course he says, oh yeah, I did file. And then, so, but it files and there's a probate. And to answer one of the questions that came up is whether or not it was notarized or not. I am not the probate guru. I do some things with it that I know pretty much when it comes to the practice, but I do know that he was witnessed and verified by the clerk of that probate court. Okay,
and that's sufficient. I noticed that it needs to either be a notary or someone from probate court, but the name that was there, I just typed it in, it doesn't come up as a Fulton County employee. So I wasn't sure which of the two, and we don't need to sort that out today. You know, if I end up saying, gosh, I think I don't have jurisdiction over this because there's this valid petition, and Mr. Clark doesn't convince me that I do have jurisdiction, then he might go after the probate petition to say, look, it's not notarized. But we don't need to work through that today.
Okay. So
it looks like a petition has been filed, and Mr. Clark's view is, so what? I mean, he puts it more politely than that, but that's fantastic. It doesn't change my ability to work through the issues that you two have presented me.
yeah, but the other stuff that comes up also and I think I've mentioned this to Mr. Clark, and I've been wondering through this whole thing, have we actually made a full title search on this to see if everything's in line and what's happening? And the reason, one of my concerns was that at some point, someone tried to either refinance or did something, and the title company had said, and this was all hearsay, had said, hey, no, this property is not in Geneva's name. It was never fully transferred. But you know what? After all this stuff, yesterday, I called a company myself, and I just said, listen, run this real quickly because I have a hearing tomorrow and I need to know. And these are the questions, and this could be something that's not there, but that further proves my point why I think this needs to go to probate court, at least held, is that while it is in Geneva's name, it was supposedly transferred at one point because of a marriage or because they were separated, right? Well, that transfer is not there. It never made it. I don't think the property. So although for mortgage purposes, she's got some mortgage, and Kimberly, at one point, if you look at the transfer, it's actually from the sister, the Kimberly, to the mother. Maybe there was some kind of question of there was a reason they need to transfer the property for some reason, but the transfer, there was never any transfer to Geneva. So there's another party that might need to be part of this probate, which is the father, who's still alive right now. So for that reason, that's the other thing. I mean, we could go on through this, and next thing you know, we're back at Your Honor because, well, you know, this is not by you. So I think I'm very happy that the probate is actually filed, and because I think we need to send it back to probate because there's a lot more issues to sort out. In addition to a plethora of liens that I've seen on the property, because I need to discuss this, but it's not the plaintiff, but they are huge, including some from the federal government probably. So I tell you, this gets a lot more complicated. I am ready to argue whichever way, Your Honor. I'm fully prepared. I've got my argument, but I think at this point, this might be bigger than you're very bright and a scholar, but I think the probate court needs to really look at it because there are issues that needs to be done that need to be sifted out more than we see here. That's the one thing.
But let's say for a minute there are liens. Let's say Uncle Sam has put a lien on it because someone didn't pay federal taxes. That's not an issue that is particularly appropriate for probate court versus any other court. When it came time to sell it, Uncle Sam might show up to say, not so fast, we get $10,000 of the proceeds. Right. And that's a problem for whomever it is. If it's dad who owns the property or it's the two brothers, they're just going to see less money if in fact Uncle Sam has a timely and properly filed lien, then that money gets siphoned off. Just like the $80,000 amount owed to Loan Care, the mortgage company. I appreciate that no one is saying that if we sell 135 Fairburn, there's going to be $1 million pot of money. Lawyers' fees may end up being what they get to spend their proceeds on. But yeah, the brother's choice. They had a chance to mediate this. They went to mediation. Seemed like a perfect case for mediation, and it wasn't. So here we are.
Well, Your Honor, I agree with you totally with the liens. I mean, I say that only to send out the message to all of them that, listen, this, you're probably not going to get anything. But the father portion that he should be on it, that's a much bigger, that's a bigger issue. Because if you look at the property, the line, there is no transfer from the father to the mother. And maybe it was supposed to be done, but that thing was never done. So the property is probably not Geneva's. It's probably the father's. And that's something that will probably, that if you let the probate petition, the probate will get to that.
So we're getting into a little more substance than I wanted to at this point. Do you have anything more you want to add about probate being the exclusive jurisdiction as opposed to parallel jurisdiction?
Yes, Your Honor. When it comes to matters like this, there's no question that for me, that the probate court is made to be able to sift through wills. It has exclusive jurisdiction when it comes to wills and to matters of probate and estates. This is a matter of an estate. It's about a property that's probably part of the estate of Geneva Grayson. There's taking it out of probate just takes put the cart before the horse. Is that we're actually trying to decide how much percentage and what's done for the property for one aspect of the estate, but the probate court, there's no argument there that there's no viable argument that the probate court is not the one that should actually handle it. And there's no statute that could be stated that takes it out of probate court. I could go into my entire argument that I have outlined in my brief, Your Honor, but I haven't heard anything that says that it's not that the probate court is not the person that has the exclusive jurisdiction on it. If we did not have a petition, maybe, then there's a question of whether or not, he probably is not going to file it. Maybe he's going to file. Well, you know what? It's filed, and there's no justification of it's not authentic or things like that. So at a minimum, right now, I think we should let the matter go to the probate and let the probate court figure out whether or not it's a petition or not a petition. But he went there himself. They told him it's okay. They did it. He signed in front of them. I don't see what's not to like about it. But I really think that we'll get a lot more of these issues resolved. At least we know what it is if we let it go to the probate court, which is the proper jurisdiction for it.
Do you know, Mr. Bastian, what the status of the case is? The petition, if that's what we call it, was filed on March 13th. So that's 4 months ago. I know things are moving more slowly. Times are complicated, and you may not be able to get a gun permit, but probate may be doing other things. Has the case progressed at all, or does it just sit there?
No, well, after it's filed, the March 13th was right about the time that things stopped, and then there were service issues. The sheriff was not going out to serve, and I don't believe that they still have gone and started. That was my question. But as far as the probate court, it's a live thing, except that all the services are not accepted. If Mr. Clark wants to accept it for his client, I think that's fine, because I told them, I'm thinking that there is probably going to be an opposition to him serving as petitioner. I mean, I'm just thinking. So for that reason, they were more quiet. Otherwise, they would have done what they usually done quickly. You would have gotten every participant to sign off, and it would have gone. But I'm thinking that there's probably, given the history between the two brothers, I'm thinking that there's probably going to be more to that.
I suspect there will be. All right. Well, that was helpful. Mr. Clark, just so I don't leave this piece behind, and this may be news to you, it was news to me. Now all of a sudden dad is on the scene. Do you have any response to either based on fact or assume father is on the scene? That doesn't change things because here's how it would come out in the wash. I certainly wouldn't want to order the sale of a piece of property only to learn that I sold something that the people who got the proceeds didn't even own.
Well, it's a summary judgment, and we put the vesting deed into Miss Grayson as part of our petition. They didn't deny that was a vesting deed, a valid deed. We're on summary judgment now, which typically, if there was a question about the chain of title, you produce a competing deed. And I just got online and looked. I didn't see any other competing deed in the husband's name. So this is all, I would just be speculating as to a speculation.
Okay.
Meaning, I mean, I can't really respond to that because I don't see a deed. But I will say, I mean, I don't, Mr. Grayson lives there under, it was his mother's house. There's nothing to suggest a title issue. And all this is to say that she owned something that we've inherited a portion of. And the probate courts are not going to look, they don't delve into quality of titles in their estate. They merely administer what's in front of them, meaning if the petitioner says 2 of the 3 children get the house, then that's what the court orders if necessary. So this concept that we need to send it to probate court so they can bless the title is, I mean, that's
not what probate court does.
Right.
Okay. All right. Well, let's pivot then and talk a little bit about the motion for summary judgment. That is why we're here. And I guess before we dive into the substance, if I go back, so Mr. Bastian filed the first motion for summary judgment about a year ago. And that would have been in response to, at that point, I guess, the first petition. He filed it before the second petition, not knowing necessarily there'd be a second petition, and certainly before the third petition. So how much, I'm trying to figure out what part of Mr. Bastian's motion for summary judgment is still relevant given how the petitions have changed. You tell me, Mr. Bastian. One thing I want to hear about, although not so much from you, it would be from Mr. Clark, would be how fatal the failure to comply with the statutory 20-day notice is. That is what 446162 says, that you need to provide notice, but it doesn't go on to say, and if you don't, you have forever forfeited your ability to seek a statutory partition. I also heard Mr. Clark clearly that he isn't necessarily proceeding that way anymore. He's thinking equitable or maybe even heirs. And I know, Mr. Bastian, you've got a perspective on equitable is not appropriate because there is a legal remedy, which would be the statutory partition, but he can't do that because he didn't get 20-day notice. So right. I guess tell me what you think you still are entitled to motion for summary judgment on, Mr. Bastian, given the changing nature of the petition.
As far as the fact that it's not, we didn't get he did not follow the procedures, as you said, that I should get summary judgment for. I hear an argument that, okay, I might not be on this, but I'm probably on this, maybe there is, maybe that one, I'll grab onto whichever one I can. But the statute is pretty specific that you, before seeking partition under the statute, the petitioner must give at least 20 days notice to other parties. And the statute provides for either physical or 2 other means of petition, but he doesn't seem to it doesn't fit into that. It's okay. I want a petition, so I'm going to jump on this part, but you still have to be able to do what the statute requires us to. So I said on that fact alone, I think I should get summary judgment because he has not adhered to him. And it seems as if Your Honor read it, because I could go through my case law, but since you articulated, I noticed that you know my argument pretty well, and reasonably well at least. Okay.
Let me see if I have other questions for you, Mr. Bastian, before I hear from Mr. Clark. I think what I'll do is ask Mr. Clark a few questions, let him respond, and then circle back to you, Mr. Bastian, to see if you have something you want to say in response. So, Mr. Clark, tell me why it is that a petitioner can choose freely from among the three forms of partition. It resonates with me a little bit, Mr. Bastian's observation that, hey, you don't reach for equity if you haven't exhausted your remedies under law, and statutory partition would be the legal remedy, and only failing that would you go to equitable partition. But maybe that's putting too much emphasis on the word equitable. It's no more an equitable action than statutory partition or heirs partition. So tell me why you ought to be free to pick which one you want. And if you're not, let's talk about that 20-day deadline for providing notice under the statutory partition.
I am free to pick whatever remedy I like as the plaintiff or the petitioner. You know, I can choose if I have alternative ways to recover, I can pick my remedy. And when we originally styled this case, it was a quiet title which is undoubtedly equitable. And that once you're in equity and you have equity jurisdiction, you can use any equitable remedy that you like, including equitable partition. That's why you almost inevitably will see a quiet title count along with an equitable partition. They go hand in hand. The accounting or rent theory that we brought also brings you into equity. And once you're in equity, you could use the equitable statute. If you do not have any of those distinct heads of equity jurisdiction, then you would, that you pled in your complaint, then you would be typically under the statutory scheme. Typically, I say, because of the fairly recent amendment to the Georgia law to add a third version of partition in Georgia, special circumstance. So there's three elements that must be met, all of which are met here for the heirs partition. I'll just cover them briefly. There has to be no agreement about how to deal with the property. We don't have any agreement here clearly. One or more co-tenants acquired the property from a relative. Well, we all acquired our property in the same exact way from Miss Geneva. And at least 20% or more of the co-tenants are relatives, and in this case, 100% are relatives. So we're squarely within the heirs partition action, and that's why I amended it once I sort of realized that once you're there, once the facts are there, unless you're in equity, which I'm not saying we are now, you have to use the heirs partition statute.
You have to, meaning that it's a directive. If you fall into no agreement on the disposition of the property,
yes, if
more than one relative acquired a stake in the property and those relatives represent a greater than 20% ownership stake, then your read of the law, and it may actually say that, I just don't have it in front of me, is that that's what you got to use. You actually should not use equitable partition.
Yeah, I think that's right. It's 44-6-181, and that says, if the court determines the property is theirs property, the property shall be partitioned pursuant to this subpart unless all the co-tenants otherwise agree. So that's why I was saying we can agree to do it equitably, but we would have to all agree to that.
Okay.
If we don't agree, I think we're bound under the heirs partition.
Okay. So you have, I don't mean this pejoratively, but you sort of stumbled into heirs partition. You started one way. As you learned more about the case and researched it more, you had version 2. And then how new, you mentioned that heirs partition is relative to the other 2 forms. It's new as in 2017, or some of this stuff new could mean 1855.
I think it's five-ish years old. Probably not 10 years old, but it's not like it happened last year.
Okay, but in the world of property, that's really, really new. It's still shiny.
That's right. I mean, this
Okay.
will be the first one I've ever done. I've done, a lot of
Okay.
property cases.
All right. So that's your response to why you don't have to exhaust the legal remedy, if you will, for statutory partition. One, we're already in equity because you're seeking an accounting, you started with quiet title, et cetera. But regardless of all that, the heirs petition statute kind of calls out saying, if you fall into this set of if you meet these requirements, this is how the partition is supposed to occur, unless the folks agree to do it a different way. And the word agree doesn't seem to come up a lot in the pleading. So I'm guessing we're not there. All right. Let's say for a moment that I conclude that really the right way to start the process would be a statutory partition. How fatal is it that you missed the 20-day notice deadline, or your client did?
I don't know. I actually haven't looked into that because I never thought that I was under the statutory proceeding. You could, I guess the worst case scenario for my client would be, okay, you didn't follow the steps, so it's dismissed, but I sent a 20-day letter and then
you refile.
Proceed. And I still would have the declaratory judgment part and the rent, and then I guess I just amend to re-add it or ask for a supplemental pleading. It just seems like a lot of procedure over form.
Okay. All right. Tell me, Mr. Clark, why the right approach is not, let's just stay this, let probate run its course. And then if that doesn't resolve it, you haven't lost anything. If in fact, Ronald Grayson is entitled to an accounting and that there ought to be, we'll call it rent flowing his way, that's going to only accumulate over time. And his stake in the property isn't shrinking or growing. That's whatever it is, whether it's a third or half or a quarter, that's not changing. Why not let probate do what probate does? And if that does not result in a partition, i.e. a sale of the property and then a disposition of the proceeds, first to the mortgage lender, then maybe to Uncle Sam, and then 52 cents to Derek Grayson and 21 cents to Ronald Grayson. Why is that the wrong approach?
Well, we went to mediation March 12th.
The day before he filed the, okay.
So it didn't work out. And this is before we were in the COVID shutdown. So it seems like a pretty transparent attempt to delay the resolution of this case, because it's in our best interest to get this done. As the person in the house, it's in their best interest never to get it done. And I point out that no one ever asked us to acknowledge the service of the petition. It's been 4 months. No one really told anybody that this had happened.
No, Mr. Bastian didn't know it had happened. I mean, that's what he's saying.
I'm sure he didn't. And so, the harm is we're going to get to probate court where it doesn't really matter the outcome. We're not going to, I can't imagine, contest the will, because we get a third of the personal property and we already have, Kimberly's interest under the real estate. So there's no point in fighting about it. Let's just get the deeds executed and then we're right back here. It just seems to be, to me, a transparent attempt to delay the partition.
Is there a minimum stake that an heir or a property owner, here we can say heir just because it sounds like that might be the appropriate partition channel that one would follow. But is there a minimum stake that a property owner has to have in the property to be able to trigger any of the forms of partition? If I owned 1% of 135 Fairburn, could I force a partition, even though Derek Grayson lives there, his family's there, they have a nice garden there, they've made it pretty, but I got one measly percent, and he doesn't want to buy me out for whatever price I'm saying? Could I force the sale of that property?
Absolutely. You could. Now, under both the heirs and the statutory, and probably the equitable if the court ordered it, you would be given the opportunity to buy out the minority 1% owner. If you couldn't come up with the funds to do that or didn't want to, then the only real, well, there's two different types of partitions actually. If it was like a big farm, you could get the court to carve out a 1 acre portion.
Right, but that's not this parcel.
Correct. So
and
yeah,
we don't have a 1% stake. It's not that anyone has, no one has such a fractional provision that it's the tip of the tail wagging the dog. So
to answer your question, yeah, that because otherwise, well, there would be a number in the statute, so if you have to have a certain percentage, and it's not uncommon really to have 20 heirs, and that's each a 5% interest, and that's not very big, but that gives them the right to a partition.
Okay.
Yeah. May I, Your Honor, real quick?
Yes, please.
Yeah, just two things. I mean, I'll be remiss and not an attorney if I say this, but we did go, the first thing is we did go with good faith to be able to a mediation. So I would just say that. So.
Oh, I don't doubt that, Mr. Bastian. I don't need to know why these two brothers don't get along. They don't get along, and that's unfortunate. But I didn't mean to suggest that anyone went into mediation in bad faith.
It's not for you, but that's not my real point. The other point that I wanted to make is that, you know, as much as we think that we got the will and that's it, we interpreted it, there are some questions under the will. I mean, when you look at the will, it says that the sister and the brother are supposed to stay in the house, right? And if the property sells, if it sells, right, then he gets the 1/3. I mean, that's what it says. So the intent of the party was for them to stay. And you know what? If money comes, then that's when you're possibly going to get some money. But you're not part of this. I mean, that's the one thing it says. So that's got to be interpreted. The other stuff is, as much as we don't want to think about this, but you know, there's still the question also as to how in the world did all of a sudden she transferred her stake. There's a validity also, because I mean, hey, listen, the deed says that she's supposedly she sold it for $10. Acknowledgement receipt has been received. Well, my client's never received any money, and supposedly he's the one that had the $10 says that she did. He never. The only time he knew about it, it was part of this motion, and then all of a sudden, the will has supposedly changed. We all kind of adopted, but that's still a question as to whether or not he still has this, or whether it was a proper transfer actually.
You're confusing me. Hold on. You're saying you now are calling into question Ms. Whitlock's relinquishment of her 1/3 or 1/2 stake? Or are you saying we're not so sure that the 2008 will is good? I couldn't tell which one you were.
No, the 2008 will, that's I don't think, we don't have a question of the 2008 will. That's not.
I don't think you should. It's better for your client.
Right. But as far as the transfer, her transfer.
Her meaning the sister?
Yeah, the sister's transfer. I mean, you know, it happened. It just happened to happen when he didn't have one, and my client was never. She supposedly give a transfer $10 acknowledgement received. That's never that was never given to my client. I mean, you're supposed to give. It's a quid pro quo that you give. I transfer this for that, but anyway, that's. But the point I'm going there is that I think there's more issues probably that the probate court would decide also, aside for who actually, it's not just an equitable transfer, but whether the estate's property is probably goes to the right person, and that's a probate matter. It's in addition to all the things that we're thinking about.
Okay.
I don't
I
have
hear
an
you.
answer to that, but I'm just saying that just gives you more reason why I think it should go to the probate court.
Okay. Well, it's there in part, so we'll see what happens. All right, I've had my questions answered. Mr. Clark, is there more you want to add in support of your motion for summary judgment or in opposition to the Derek Grayson motion for summary judgment?
Well, I just point out that it is summary judgment, and it's it's supposed to be on if there's a dispute on the facts, it should be that dispute be brought into the record by affidavit or other admissible testimony, deposition testimony. There is no dispute, as far as I know. There's a copy of that will that's never been authenticated by any affidavit, although I haven't made a big deal about that because I just say take it as is. It doesn't change anything.
Right.
Same with this. Probate filing, it would be a supplemental pleading to say that something has happened since the filing of this complaint that typically requires a court order to allow you to use that as evidence. And again, I haven't made a huge deal out of it, but I mean, procedurally, that's the way it's supposed to work. But it doesn't, in my mind, change anything on this.
Well, and I can always take judicial notice of, well, I guess technically probate court's not my court. Because I know I can take notice of things that are in dockets of courts here in Fulton County.
Right.
But to your point, I don't know that it changes a whole lot unless I bump into that case that says a la bankruptcy. If probate has been triggered, then everyone needs to back away from what's going on. And I'll certainly review again, Mr. Bastian's argument and the cases that he cites in his briefs that support his claim that I now lack jurisdiction over the dispute.
Thank you, Your Honor. Yeah, I mean, mine's pretty simple. He should have followed, well, should have followed what he has to, and he should be in probate court. That's
Okay.
okay.
Well, good. In the meantime, I assume Mr. Derek Grayson is doing fine. Does he occupy that house all by himself? Does he have family in there? Who lives there with him?
I don't know, Your Honor. I know he lives there, but I'm not quite sure.
But he occupies it.
He does.
Ronald Grayson lives somewhere else and is interested in getting his share of that property. And Ms. Whitlock has said, keep me out of this, please. Okay, well, good. Well, gentlemen, I appreciate your time. We will get to work on this because it needs resolution. It's unfortunate that March 12th wasn't a magic day for the parties, but we'll make someday soon a day where there is greater clarity as what's going to happen to 135 Fairburn. If anything comes up in the meantime that needs my attention, please let Ms. Niles know, and we'll jump on it. Okay. Anything else, Mr. Clark?
No, Your Honor.
All right. Enjoy Lake Lanier. Mr. Bastian, anything else?
No, thank you. Thank you for your time, Your Honor.
All right. Appreciate it. Everyone take care.